It's a pleasure to welcome Michael Salter onto the channel. Michael is an employment law barrister from 42 Bedford Row and also sits as a part-time employment tribunal judge. Michael is going to talk on the topic of misconceptions that people have about employment tribunals. Thank you so much for joining me, Michael.
Hi, Matt. Thanks very much for having me on the channel and for the very kind words. Hopefully, I can add something to the knowledge that you're imparting with what I see are the top 10 misconceptions about employment tribunals. Now, I think we've got to understand that tribunals were created by Parliament and an Act of Parliament, and so the powers that they have and don't have arise from those acts. And this, I think, has given rise to some serious misconceptions about what the Employment Tribunal has authority to do. The first misconception is the high financial awards. The media cover, obviously, the high-value cases, the cases where bankers have been discriminated against and so lose a career-long loss. But the statistics show that the average unfair dismissal award is a little over £10,000. And what people don't understand and don't realise, or may not realise, is there's actually a ceiling on what you can receive, and that's either 52 weeks' pay or a sum of £88,000, whichever is the lower. Now, there are exceptions to that if it's a whistleblowing case or if there's discrimination, but most tribunal awards are relatively modest, and many of the claims that come before employment tribunals have little, if any, value. Financial value at all. For instance, we have a power to give a declaration as to what your contractual terms are. No compensation comes from that, but it's a very important right for workers. So employment tribunals aren't a place that litigants go to get rich. The second misconception is that you can only settle your case before the hearing starts, and that's frankly incorrect. A case can be resolved at any point by the parties talking to one another, negotiating between themselves or using a mediator for mediation, up until the tribunal gives judgment. Now, whether or not it's likely a case will settle whilst you're at tribunal is a different matter, because there are economic reasons why one party, if they've got a lawyer, might not find it economically viable to settle, having incurred their lawyer's fees. Thirdly, although less formal than the High Court or a county court, it is still a formal setting, even for video hearings. When you're conducting the case from your living room or from your kitchen or on the kitchen table, you are still involved in a court proceedings, and the rules still apply. You can still be found to be in contempt of court, and it's a criminal offence to be recording the hearing. The judge should alert you to that at the outset of the hearing. A fellow employment judge tells a story of someone during one of his hearings breaking out sushi and starting to eat. You wouldn't do that in court, so why on earth would you be thinking it's appropriate to do it in your video hearing? Fourthly, just because you've complained about something at work doesn't mean that the employment tribunal will hear the complaint. Your complaint has to be in the claim form. The tribunal's powers, as I say, are very, very limited, and we only have the power to hear what is complained of in the form. There may be a whole backstory and a whole litany of complaints that you have, but unless they're in the form, that's the only way you get in front of an employment tribunal with your claim form, your ET1. You have to use a particular form, and if you don't and you want to introduce it later, then you have to make an application to amend, and that's not necessarily automatic. The fifth misconception is that subject access requests are the same as disclosure. They're not. A subject access request you make to your employer or your ex-employer, and they will respond and give you the information that you hopefully give you the information that you're seeking. Disclosure is a different beast. Disclosure is a formal court process whereby you send to your employer all relevant documents. Those are documents that are relevant to the issues that your claim gives rise to, and at the same time, the employer will send you copies of their documents. So they are different. Just because you get some documents in disclosure doesn't mean you'll get them in the subject access request, and vice versa. And also, the Employment Tribunal has no power to say whether or not an employer's compliance with a subject access request has been appropriate or not. That's for the Information Commissioner, and certainly not for employment tribunals. The sixth misconception is about the actual claims themselves. For instance, what the major claim, or one of the largest claims that it's heard by an employment tribunal, is called unfair dismissal. Now, you might think that's all to do with fairness. It isn't. It's to do with reasonableness. What's fair to me is not, or may not be, seen as fair to you, or fair to any of your viewers, Matt. The law requires the tribunal to see whether or not the employer, the respondent, has done what a reasonable employer would have done. Whether or not the employment tribunal agrees with that process, I, when I sit as a judge, can often disagree with the way in which an employer went about carrying out its investigation into misconduct. But that's not enough. And if I was to say that I take a different view, therefore the dismissal is unfair, I would be appealed. What I've got to look at, and what the law looks at, is whether or not a reasonable employer could have done what this employer did at the time. The second misconception about claims is bullying. There is no claim for bullying in the Employment Tribunal, and bullying per se is not prohibited by law. If it's because of or related to race, sex, or any of the protected characteristics under the Equality Act, then it might be an act of direct discrimination. It was done to me because I'm a man, or it could be harassment because it relates to my sex as a man. Then it can be prevented, or it can be outlawed. If, however, you quit your job as a result of the bullying, then you potentially could have a claim of constructive dismissal. However, bullying by itself, without it being linked to a protected characteristic, or without it resulting in you quitting, you can't bring a claim in the Employment Tribunal for. A point I raised a few moments ago was about discrimination. Now, everyone has bad things happen to them, whether or not you're pushed in front of in the queue in Tesco's or whatever. That's not discrimination, unless the treatment is because of, again, one of the protected characteristics. So simply because I'm pushed in front of in the shop and I'm a man doesn't mean I've got a sex discrimination case. I've got to show, and the burden initially is on me to show that I was pushed in front of because I was a man. The seventh misconception, and one that lawyers often fall into the trap of, is by overloading the claims that they put before the tribunal. The more claims you put in doesn't mean you're more likely to win. The flip side is that it might be the tribunals think you don't understand your claim if you've thrown in every sort of discrimination, two different sorts of dismissal, whistleblowing, and all those sorts of things. Lawyers call it kitchen sinking a claim, and tribunals are distinctly alert to it. The eighth misconception, and a really, really big one from my personal experience, is an employment tribunal cannot order an apology and cannot order a reference. These are matters that the tribunal simply has no power to compel an employer to provide. Parties, as I said earlier, can negotiate, and these are matters that can be part of the negotiation. But don't come to an employment tribunal thinking that you can walk out the door with a reference under your arm, or with an apology from the employer. That we simply cannot compel that. Closely linked to number 8 is my penultimate misconception, and I've lost track of the number of times I've had claimants, again, sometimes represented by lawyers, say, I want you to find I did not do the act that they're accused of, or I want you to clear my name. Again, we can't do that. If you're adamant that you did not commit the act of misconduct, and we found that the employer did unfairly dismiss you or did wrongfully dismiss you, you are still going to have been dismissed because of gross misconduct, even though you've got a finding of unfair dismissal against you, or in your favour rather than against the employer. So please do be aware of the limitations that we have. Again, showing how different it is from a court. There's a misconception about costs. Heaven forbid, if any of us walked out on the street after watching this video and got hit by a bus, you could issue a claim in the civil courts for personal injury, and if you win, chances are you'll get your costs. The usual rule is that the loser pays the winner's costs. That doesn't apply in the employment tribunal. The tribunal is cost neutral. That the presumption is that all parties bear their own costs. Now, don't come to an employment tribunal thinking that you will win, or if you win, you will get your costs repaid. That is very, very much the exception. So I hope that's been all right, Matt. If you or any of your viewers want to get in touch or have any questions, I'm sure they know how to do that. But it's been a pleasure, and I look forward to catching up soon.
Thank you so much for coming on the channel, Michael, and sharing your experience. It's really appreciated. Thank you. I hope that you all found the video helpful. For more information, do browse the channel and visit my website. Remember that this video is for guidance only and should not be relied upon for specific advice. Also, the law can change. And finally, please subscribe to the channel for updates.